Models are things that have to be used with great care. My analogy always is, you know, in trial work, the stove is hot. It doesn't look hot. It doesn't look like it will burn you. But if you're not careful and you touch it, you will burn your fingers, and perhaps worse. So, panel, use of models. You may have other stories about this, how you all use them, how you don't. Comments about that?
Talking about, I mean, just when in my experience in dealing with these sort of models, and you bring up the point about knowing your audience, I think you kind of have to look at it from a standpoint of how this is going to affect the client. I mean, it's not just the insurance company and the law firm. You have a client that's out there and insured, and you kind of have to look at it from a reputational risk. I mean, you look at a products liability type of case, and in preparing these models internally, knowing the audience and seeing how a client is going to react to something like that, I think you have to take into consideration as to the effect that it's going to have on that customer. And presenting that information internally, how it's going to affect all parties, I think is something that's really kind of needs to be looked at as a whole. And how the evaluation is going to determine the exposure that's going to ultimately hit the client.
I mean, from my perspective, it's it's later on, right? I mean, it's from a juror's perspective, and as Fran mentioned, it's generally a smoking gun document when those models are used or created by the business people to measure exposure or liability. Those are the most damaging documents that a jury can that you could put in front of a jury. So the trick from this side, from the jury side, is to how do you deal with those documents? How do you explain what those models are? Getting stuck into the science of those models or the quantitative analysis that went into those models is a difficult play in front of a jury. They want to hear from the business people. They want to hear and understand what they meant by we're going to have exposure here, I've seen Houston, we have a problem as a narrative to explain what their models are, and those are difficult things to deal with as a trial attorney, and certainly as a jury researcher, to understand how to explain those models to a jury.
And then I'm on the front end as an in-house litigation attorney. Most of the models that I deal with are intended to inform business decisions. And let me just say, it's a scary thought to think that it would potentially be possible for one of those to ever be seen by a jury. And it's definitely something that needs to be thought of and considered. The good news is, of course, most of the things that I deal with would fall under privilege. But what the question I always get is, what is our maximum exposure here? Well, there's a tricky thing with maximum exposure. The maximum exposure, we can imagine all sorts of horribles, and if that's the only data point that you give your business people, you know what your mandate will be. Settle the case every time. So it's more important to put things in context, not just to give raw numbers. We can all imagine the worst case scenario. What I prefer, if I'm asking outside counsel and I'm charged with creating a model, is yes, I need to know the worst case scenario, of course. I also need to know, more like a continuum, where are we looking at? What's the most likely scenario? And what's the best case scenario? Because it's only when you can put your models into context that you really give the business people the ammunition to make a correct business decision.